Thank you, Catherine. Good morning, everyone.
Good morning. We're going to be really cozy today. So we're both
Yeah.
on the screen. Let us know if there's any issue in seeing us. And welcome.
Okay, so just what we're going to try to do today, and I think the sort of the comments we've had planned, many of which will address the questions that you guys thoughtfully got together and thought about and sent in ahead of time. We hope to cover those through the course of the presentation. And so we're planning for probably up to about an hour, but hopefully we'll incorporate the majority of the questions that were asked, and feel free to chat in if we haven't quite answered it, and we'll pay attention to that as it's coming in. But so I'm going to do a bit of an introduction as to why we're interested in privacy and consent at the Change Foundation, and how we came to produce this report, and then turn it over to Mary Jane, who will introduce herself to you and do the overview of the privacy and consent legislation and some of the parts of the report, as well as hopefully answering many of the questions that you've submitted to date. And then at the end, we'll have time for some other questions and answers questions that may have come up. So the Change Foundation, over the course of a year between 2015 and 16, we engaged with family caregivers and health and community care providers across the province to understand caregiving in Ontario from both perspectives. And while we elucidated many themes on what gets in the way of making that relationship between family caregivers and the healthcare system a better experience for everyone, we also heard some concerns from both groups about lack of knowledge or lack of universal understanding about the privacy and consent rules. So it became apparent to us that we needed to do a bit more work on trying to put the interpretations of the privacy and consent regulations and legislation into plain language that will be helpful not only for our project but for others in the province. So what we heard from caregivers was that providers often said they couldn't share health information for privacy reasons, which in many cases is legitimate, but sometimes it was just put up as a barrier. We also heard from providers that they were uncertain sometimes about privacy and consent rules. So rather than investigating it or having an easy resource put up their hands and say, no, I can't share things with you. And the legislation was often used as a reason as to why information couldn't be shared, even sometimes in cases where consent had been given by the patient. We know that caregivers face many information-related challenges, including often having to ask repeatedly for copies of health records from a variety of providers that are supporting the person. They're sometimes refused access to copies of test results or other health records that might be helpful to them, and sometimes ignored by providers when they want to contribute important insights and updates to provide information about the patient's health. So communication between caregivers and providers is a key piece of work that we're trying to get right, but specifically around consent and health information regulations, it's a challenge. Providers also told us about the challenges they faced. It was hard for them to respond to a caregiver's request for information when they didn't have a clear record, an easily discoverable record that the caregiver was legally authorized to have the information. Sometimes it was hard for providers, to identify the primary caregiver in a family where there's multiple family members, and we'll cover some of that in the discussion to come. And it was sometimes hard to work with family members of patients where the patients were incapable of making their own treatment decisions when the family didn't agree about the best course of treatment. So we hope the report clarifies some of this stuff and hopefully opens the door for an informed discussion between providers and family caregivers. So our report is called Making Privacy and Consent Rules Work for Family Caregivers. And it offers a primer on the current legislation of both the Healthcare Consent Act and the Personal Health Information and Protection Act. The report includes descriptions of legal tests for capacity, and then rules about collection, disclosing, and accessing personal health information. And it also provides some rules for when the patient's deemed incapable to consent, and the hierarchy of substitute decision makers, which Mary Jane will elaborate on in a moment. As well, we've included case studies, which we're not going to go over today, but I think you've seen those in the report that was sent out ahead of time. So those just help to kind of illustrate situations where the rules are applicable. So I'm now going to turn it over to Mary Jane Dyckman, who, as Catherine said, we worked with on producing this report, and I'm going to let her introduce herself and take us through the discussion today. So thank you.
Thanks very much. Very pleased to be here and pleased to be part of this particular group in Cornwall, because you have some additional layers working in mental health. And I've been working in mental health as well for the past 20 years. Started my career in the Ministry of Health back in the day when they used to run the 10 mental psychiatric hospitals, and worked at the patient advocate office for a while. So we heard very clearly then, and my take is that the issues haven't really changed in terms of the flow of information, some of the barriers that caregivers face, and also some of the, sometimes call it privacy paralysis that we see with the healthcare providers, who, as Genevieve has said, want to make sure that they are authorized to be sharing information. And there may be barriers in that where the information is recorded, they don't have ready access to it, and sometimes the default is no, I can't talk to you, or I can't share it. And then the caregiver, who may or may not be the substitute decision maker, that's the other wrinkle, is then left to navigate or try to convince. So part of what the Change Foundation wanted to do is to level the playing field a little bit, make sure that the same information is out there to the benefit of caregiver, substitute decision maker, and healthcare practitioners and other healthcare organizations that are actually providing the care. And we're not going to go into detail today about all of the discussion over many years in terms of the policy considerations and everything else around privacy, around changes to healthcare consent laws. This document and this initiative is really intended to, again, provide that base information and address some of the situations that many of you have experienced over and over. And I did work on the health privacy legislation. We call it PHIPAA for short. So I did, while at the ministry, and then a bit later, go back to consult with them on it. It's not to say that I love everything in it, but it is what it is. And I had just come out of working in mental health daily at the time we were drafting. So I was always trying to think, what will this family do in the circumstance? How can we put it in the hands of the people using PHIPAA to make sure that they are well equipped and can have a conversation? Because we were saying the other day, it's not enough to just put up a stop sign and say, privacy, I can't talk to you. Let's pull the layers away and have that nuanced conversation. So let's jump in. And again, as Genevieve said, we've tried to embed some of our comments integrated with the questions that you have put forward. So first of all, we understand for sure that people are quite frustrated that healthcare providers won't speak to them. Again, from a privacy paralysis point of view, or lack of information, or the speed at which care is delivered and these interactions take place, sometimes that uncertainty, I don't think it's intentional on the part of providers. I suppose in the rare case it could be, but really it's that moment when someone's saying, well, I want to share information with you, or I want access to a report, and there's not real clarity or a path through to get that sorted quickly. So it is frustrating sometimes to caregivers when they perceive those barriers. And when I say perceive, I mean it can be quite real. Or there's even suggestion that, if I bring my loved one into an emergency department or to a family meeting or something like that, that it's said that we don't want the person in the room. So who is right? So let's go to an example then. Let's say that, parents of a young adult with mental illness. So I'm not talking 11 years old or 6 years old. Let's say that the person is late teens or whatever. We're going to come back to some rules about kids. But what does that provider do? Well, we said that if the provider can't get the information directly from the patient, there's actually a very obscure provision in PHIPAA, the health privacy legislation, that says, even though the general rule is that the health practitioner is supposed to be collecting directly from the patient, there's this rule, not well known, that the practitioner actually can collect it directly, let's say, from the parents, if they cannot get it in a timely or accurate way from the patient. So that's something to consider, that if you are going to rely on that provision in Section 36 of PHIPAA, is something you would probably want to document, that I collected information, let's say, from a parent of this patient, and here's why. Now, that's different than where the law actually authorizes you to collect it from the parent. So an example would be if, let's say that young adult patient is on a Form 1 under the Mental Health Act, and we know that a Form 1 permits the collection of personal health information. So right on Form 1, it says you can collect collateral information. We're talking about a different situation where there is no Form 1, and you can collect the information if you can't get it directly in a timely or accurate way. There's some other provisions that we always point to, and the one that I can't say is my favorite exactly, but the one that I come back to very often because I work in community mental health and addiction, there will be different situations where the individual is going from one provider to another. We're going to pause for a moment. I think we might switch seats just because we're having some sound issues potentially.
Oh, okay.
Do you think that'll work?
Sure.
Okay, hold on. Okay, so you'll tell us if microphone's on this side, so
Okay.
you'll tell us if you're having any trouble, and I'm going to use my loudest voice. So I don't want to single out mental health settings, but whether you have a mental health unit in a hospital or a standalone mental health facility, community mental health and addiction, involvement of other practitioners in the community, one of the things that we want to protect against is that where information can and should flow, that it doesn't in a situation where there is risk of harm. And so there's a special provision, Section 40 sub 1 of PHIPAA, which says a health practitioner can, it's not that you must, but you have the legal authority to disclose the patient's personal health information to reduce or eliminate a significant risk of serious bodily harm. And it's in the slides, it's in the report, but it's to reduce or eliminate a significant risk of serious bodily harm. So we call that a discretion to warn. It's not a duty to warn, it's a discretion. You do not need consent, and it's a disclosure to any person. So a health practitioner should never feel privacy paralysis, and a caregiver could even say, look, I've got information that's going to be important because here's what's happening at home, and you have authority to collect it on that timeliness and accuracy provision, and this is information that you need. So we need to make sure the information can flow both ways, and that's not going to happen every day, and this is not to single out mental health clients as being particularly more at risk, but it is available, and nobody should feel privacy paralysis. The Privacy Commissioner said years ago, it should not risk lives. Privacy is not meant to operate in that way.
Thanks, Mary Jane. We did have a couple of questions from the Cornwall group that related to when a caregiver does share information in these kinds of settings or other settings, or makes a phone call or sends in a letter about a patient. We were chatting before the call started about, because there was a question about what's the legal responsibility about documenting that, what's the provider's legal responsibility for documenting that in the chart. And I think the conclusion that we kind of came to was really it's not so much a legal authority, but a standard of practice and a professional responsibility to record relevant and pertinent information. So do you want to add a comment to that?
I do want to comment, because back to those collection rules, again, the general rule is you're not to be collecting it other than directly from the person, unless you find some other authority, for example, the timeliness or accuracy. So a very practical example is, let's say the parent of the patient then calls you, the practitioner, and says, "Hi, it's Mary Jane. I'm calling about my daughter. I want to tell you," laundry list of items, including potentially some risk items. So the technical piece in PHIPAA is that practitioner is going to have to consider, well, do I have the right to collect it? Well, guess what? They did collect it because it's on the voicemail. So technically it's a collection. We have to be practical. People have to be able to run their practices. And so assuming that it was collected, you know, you can say, well, I couldn't get it in a timely or accurate way. The person just left all of that on the voicemail. And I mean, that is going to be fine. I know sometimes practitioners, again, I think I've said privacy paralysis more than a couple of times already, but people are genuinely concerned because there's a lot of press right now, front page of the paper, privacy breaches, cases that go to the health regulatory colleges, like the College of Physicians and Surgeons and College of Nurses. There are consequences as well. So, you know, we've heard that different groups are suggesting that the sanctions for breaches of privacy can be quite large. So to be really clear, PHIPAA has some potential monetary fines, if you will. They've never been applied in Ontario since November of 2004. There are Attorney General prosecutions, which are in the rare cases of really egregious breaches and organizations that didn't do their due diligence, or someone who went rogue and started to do things, you know, snooping and the like. So the Attorney General can step in. There have been very few monetary fines. There is a case at Rouge Valley of staff selling RESP related information to RESP providers about mothers and babies, and I think that resulted in a $36,000 fine. I'm not aware of jail time or anything as severe as that, but that said, there are reputational risks. A practitioner could face the sanction of the college, for example. It says in every confidentiality agreement that a staff will, or vendor or whomever will sign, it'll say, you know, you are responsible, we take privacy seriously, we'll protect confidentiality of information, and if you breach, you could face penalties, sanctions, up to and including termination. And many healthcare organizations have put those in their policy.
Great, thanks. Hopefully that addresses the question that came from the group.
I want to address another one as well, though, that the legal time frame in terms of when information can be collected, there's nothing in the legislation that says you can only collect from a caregiver within a certain time. Now, maybe someone has a policy that says that, but in some ways, without having reviewed it carefully, I don't know why that would be the case. Maybe there's an intake process that's used, and as long as you have the right authority to collect from a caregiver, that's great. But I would have thought if there's consent of the individual or some legal authority, you will collect when you need to under the legislation.
So Mary Jane, that leads to one of the other questions that was submitted was, is there an expiry on consent? So
yeah, so
can we talk about that for a moment?
Yeah, so, and again, consider that a consent is not just a piece of paper that gets signed. So maybe there's a conversation with that patient signs it. It doesn't mean that it's held in stone. You can go back and should go back periodically and revisit. You don't want to hammer people with consent issues, but to say, oh, I see it says right here that, you know, you will allow us to provide that information to your parents. Is that still fine? Again, we don't want to disturb the situation, but it's merely a piece of paper. It's really meant to be a conversation. So a consent technically would stay in place until it's revoked. And I don't personally like expiries of consent being written onto that piece of paper, because again, that can lead to that privacy paralysis where staff might then say, oh my gosh, we're now out of time, the consent's not valid, and we need consent for something important, and now we're not going to do anything about it because we don't have consent. So that's the
good.
issue of having a consent that only lasts a year, because that patient might not come to that meeting at the time to renew it. So there's no need, no witnesses needed, no time frame needed.
Thanks, that's very helpful. Okay, let's move on to the situation where when a patient capably tells the provider not to share information with the caregiver, so stopping the information going to the caregiver. So what are some strategies that can be used in that situation?
Yeah, it is difficult. And again, we don't want a practitioner to simply respond with, well, thanks so much, with a checkbox that says, yeah, that conversation's over. It can be quite a nuanced conversation. Again, all of the privacy rights sit with that patient. If that patient is capable, he or she gets to decide. So even that issue of what if I'm being asked to leave the room? Well, typically people can have a support person with them, but I always say to practitioners, read the room. If there's any sense that the patient is uneasy or is giving you answers to questions that clearly indicate that they're uneasy for whatever reason, potentially to do with the person in the room, then at some level it's acceptable to say, I wonder if you might step out for a moment, because you do need to know that you can presume that you have the consent, that the person is capable, but again, I think sometimes you've got to read the situation carefully. And an example would be, let's say a couple comes in, and I don't want to single out on gender, but let's say that the wife is consenting to have her husband in the room, but it's clear in the body language that there's a level of discomfort, and it could be the same situation played out with other family dynamics. And so practitioners, of course, need to be able to read it and source out. I mean, we even had a case one time where the patient said, I know that's what I said in the room with my family member there, but I don't want those health records released, or next time I don't want the person in the room. And if I say that out loud, there's, that's a rare and extreme example, not the case with the vast caregivers. But again, I say read the body language as well, and take it from there. So in terms of the nuanced approach, I encourage health practitioners to have a conversation. So let's say that patient says, I don't want anything shared with anyone ever. Well, that's a very tall order. And the first question might be, well, what's your concern? It's your right, but what is the concern? Is there something that you'd like to talk about? Is there something that we can provide? Because, by the way, your family member is going to be coming, the caregiver will be here, we're going to discharge you, or you're at a community appointment and that person's going to pick you up. It would be really helpful, especially if they're going to be responsible for your care, if they had at least this portion. Because I think sometimes we say, do you want to share the information with your caregiver? And the person pictures, the entirety of a 10-year health record being handed over for someone to pore over. And there's a lot of sensitive information, and even information about the caregiver could be in there, but that is the record of the patient. So I say, don't just take no for an answer. Have a bit of a nuanced conversation and point to the support that the caregiver may be able to provide and why the information would be helpful. Ultimately, maybe there is a middle ground. And then, of course, if there's not, it's going to be up to that patient capably to say no. And again, we appreciate that this can be extremely frustrating for caregivers who just want the best thing for their person.
So it sounds like it opens the door to have a conversation. If things are starting with a no, and to try to come to some more compromised solution.
Yeah.
So is there anything healthcare providers can offer to family caregivers if the answer is still, a very hard no from the patient? What other things can healthcare providers offer to the family?
And it might feel a little bit hollow to the caregiver, but we were considering, well, what else can we give the person? If ultimately the patient is capable and refuses to share personal health information, and we can cajole and invite and ask the person to do it. If it's ultimately a no, well, what else can we provide? So what other supportive information is available? Again, in some ways you even have to take care with that. So it might be a long-standing clinical issue for that patient, such that it's clear that the caregiver knows what's going on, knows all of the past diagnoses and interventions and everything else. In a new situation, if that caregiver is saying, I want to know everything, well, if you start saying, look, we have brochures on bipolar disorder or schizophrenia, that's assuming that that caregiver even knows. So a practitioner is put in a slightly awkward situation of gauging what is it that they can point the person to, what resources that are appropriate, but don't get into the weeds about that patient's situation. Links to resources, other supports that are available to families, etc. There are other provisions we pointed to that we don't have to treat in detail, where you can also talk to, a practitioner can speak with a potential substitute decision maker. They're allowed to use the health record to try to find the correct person. As you alluded to, sometimes it's not even clear immediately, and we'll talk about the hierarchy of substitute decision makers if and when we're switching into the mode where that particular patient is actually incapable, and that's a finding, and then we move to that hierarchy as well. There's an odd provision also in PHIPAA, just to alert any of you who are part of a hospital or even a long-term care home. Those are the two situations where it's almost an implied consent that you can share my personal health information with someone who simply calls in. And that's only if that healthcare organization has done a couple of things. So they have to somehow have made clear, maybe through their notice of information practices that they post or put online, that they will share if someone calls in. And what they can share under PHIPAA is, yes, she is a patient or a resident of this hospital or long-term care home. Not only are they allowed to confirm, unless the person's withdrawn the consent, but they can rely on implied consent to say, yes, she's here. And we can also say where the patient is. Now, to my mind, and in the drafting of PHIPAA back in the day, I remember thinking, wow, that actually seems a bit intrusive. You could actually say, I am on the mood disorders unit, or in a public hospital, you could say, I'm in labor and delivery, or I'm on the cardiac unit. That's a lot of personal health information, but that is one thing for anybody attached to a hospital, and that's why usually the information desk will send the flowers through or confirm that the person is there and where to find them, and even their general status. So just so you're aware of that. But that doesn't work for all of the other health information custodians, community mental health and addiction, community health centers, family health teams. That's not available for any of those groups.
Okay, thanks for talking about that special situation. So now let's talk a little more about the patient's capacity to consent. And when we're looking at capacity to consent, are we talking about consent for treatment or consent for information sharing? We got a question from Cornwall about if someone who is psychotic, how can we possibly think that's okay for them to make their own decisions? So can you walk us through what the sort of legal steps are in getting to whether or not somebody's capable to give consent?
Yeah, so we'll talk about the legal test in just a moment, but let's start with that question. And again, that is a source of frustration for caregivers who appreciate the full realm, perhaps, of where that patient has been and the course of the illness. And what we've all learned in mental health is the cyclical nature by times of how these things happen. The course that someone gets put on medication, maybe with substitute consent, they start to do well, then they lack the insight. They're doing so well that they think, well, I don't need this medication, I'm going to go off, and we're back down into that cycle. And so in Ontario, it's very clear that we have a couple of different statutes at play. We've got the Healthcare Consent Act, which governs treatment and admission to long-term care. We'll talk mainly about treatment. And you can be capable to consent to treatment, for example, even when you are involuntarily detained under the Mental Health Act, two separate statutes. So if a person were to come in, meet the criteria under the Mental Health Act, they come in within and are kept for up to 72 hours, there are going to be assessments and observations and a decision made. Simultaneously, someone is going to be assessing them as to their capacity to consent to treatment. So potentially it is going to end up remaining capable. I mean, in the psychosis example that you've given, a couple of things might be at play. I suppose there's theoretically the possibility that they could meet the legal test that we're going to talk about, but there's also another layer in terms of, well, what if that patient had a prior capable wish not to be treated? So they may be ultimately incapable, but then they still can't be treated with substitute consent because they have a prior capable wish saying, I never want to be treated with antipsychotics. And again, we've had cases at the Consent Capacity Board where that's exactly what's at play. So one is, are they capable? And we'll talk about the legal test. And then even if they are found to be incapable, can the practitioner who has proposed the treatment go ahead and treat them? And so those other things come into play. So a couple of quick things before we do the legal test. On this slide, we're looking at the presumption of capacity. So each of us would be presumed capable to consent to treatment. Again, the proposing practitioner may have to turn their mind to, well, is it reasonable to presume it in this case, or in the circumstance, and again, we'll use the psychosis, well, okay, let's actually move forward and assess the person according to the legal test. Age is not the test. So whether someone is 14 years old or 89 years old, it is not a function of either age nor diagnosis. So even if I have a diagnosis of schizophrenia or bipolar disorder or major depression, I may still be capable to consent to the treatment. And that's separate and apart from whether the caregiver and the rest of the family think that, well, this is a really bad idea. Right now, each of us capably is allowed, if we're capable, to make bad choices. And we can and do presumably make bad choices, but that extends to anyone who's capable, even if they have a mental health issue. So diagnosis and age are not the factors in terms of treatment. You can be capable for one treatment and not another. So a person, even if involuntarily detained, even if incapable to consent to any psychotic medication, may be able to make a decision about, having ankle surgery or whatever else. It's going to go to the legal test at that point in time. And if they make their own treatment decisions, and those may be treatment decisions that we would all agree are poor choices. You can make poor choices if you're capable. And then there are other rules around informed consent that we don't need to go into detail here. They're in the paper as well.
Thanks, Mary Jane. So, the big things I heard there are the age and diagnosis are not what are the tests for capacity. So what are the legal tests for capacity, and how important is it to get this right?
It's extremely important. I'm not at the Consent Capacity Board very often, and that's this independent arm's length tribunal, administrative tribunal, that reviews these situations. Many of you will be familiar with it. You may have been in front of that tribunal before. The first thing that any lawyer for a patient will do, if there's a review of treatment incapacity or involuntary status, for example, if we're in the treatment realm, the first thing they're going to do is look at the test, and did the health practitioner get the test right? So here's a test for capacity to consent to treatment. And I do want to point out, when we were drafting PHIPAA, we used the same legal test in terms of health information. So you could swap in anywhere that it says treatment, we could be talking about consent to the collection, use, and disclosure of personal health information. One thing that you should know right up front is a substitute decision maker for treatment automatically steps into the shoes of that patient and also makes any of the related information decisions. But let's just go back to treatment for a moment. So what's the legal test? And why is it so important, even in documentation, that it be put down correctly and articulated correctly and applied correctly? Is because it has to do with my ability to do two things. And it's all about my ability to understand the information that the practitioner is giving me that's relevant to whatever is being proposed, whichever treatment. So am I able to understand the information? Not do I understand it? Because if it's only about my understanding, it might mean that the practitioner didn't give me good information in the first place. It's cognitive. It's my ability to understand the information. And then in addition to that, you have to meet both prongs of the test to be capable. The second prong of the test is my ability to appreciate the reasonably foreseeable consequences of agreeing to the proposed treatment or of declining it. And I can say that what we've learned over the years is that sometimes you get quite a savvy, sophisticated patient who meets the first prong of the test. They're cognitively able to understand the information. They may have a conversation with the practitioner about it. And then they flunk the test on the second piece, which is their ability to appreciate the reasonably foreseeable consequences. So an example would be that patient for whom, you know, cognitively they understand the information, but then they'll say, well, it doesn't apply to me. Or they are unable to appreciate the fact that they will lose their housing. They will lose whatever other services that have been put in place. It may impact their employment if they have a job. So there may be consequences. They just do not have the ability to relate what's on the table, what's being proposed for them as a treatment, back to their own condition. They may deny that they have the condition. They may have no insight into the fact that they have a mental illness for which treatment is being proposed. So it's really important that for practitioners, write down that, you know, if you're doing an assessment, that it is based on the person's ability to do these two things and why the person either passed the first or second prong of the test, and lay it out in that way, because guaranteed if it gets reviewed, that is the first thing that will be asked at the board or in some other setting is, do you know the legal test for capacity? And sometimes people will answer it, oh, it's understanding and appreciating. No, it's the ability. It's, can I cognitively do that?
Okay, thanks, Mary Jane. That was good. That was a good overview. So now let's move for the next couple slides and talk about substitute decision makers for when a patient is found not capable. And I know you guys submitted a question around special circumstances around young adults and age-related ability to consent for treatment, et cetera. And we're going to cover that in a couple minutes. But first, we're going to spend a couple minutes talking about substitute decision makers and that hierarchy.
Okay. So always important to have this hierarchy. Everyone in Ontario has a substitute decision maker. So anyone online with us today, anyone in the room, you should recognize your own person. So just going very quickly from the top, guardian of the person. Guardianship is a court application. Not every family will have seen that happen. I've had very few guardianship cases over the years. The exception may be in where a person has a developmental disability. Sometimes we will see the parents or a sibling step in and go and seek guardianship. But guardianship costs money, and it can be a longer, protracted, and quite intrusive taking over of the decision making of that person. And there's some other options that you might come to first. So setting aside guardianship of the person, because it is rare. Attorney for personal care. So that is not a lawyer. That is a person named in a power of attorney for personal care. And that gets written under the Substitute Decisions Act. There's an Attorney General toolkit. I could download it today and sit here and say, Genevieve, I would like you to be my substitute decision maker. I'm going to name you attorney. Maybe I'll name a substitute. Maybe I'll give some instructions about particular types of treatment or care. that makes sense to me. When a person signs that power of attorney for personal care, there are treatment decisions under the Healthcare Consent Act that fall under it, and there are also other types of decisions, personal care decisions that are not treatment related, but things like shelter, things like nutrition. So those are other pieces that can be considered. So you may or may not have a power of attorney written. If you don't, in Ontario, as I said, everyone has someone on this list, and we'll tell you why. And we'll come back maybe to the attorney for personal care situation. A representative appointed by the Consent and Capacity Board is going to be a very rare option as well. So the quick way to describe it is, let's say I'm involuntarily detained in hospital and there's a question about my incapacity to consent to treatment, and the practitioner's looking for the right person to make the decisions. They come to this, and it's possible that even though I'm incapable and I'm involuntarily detained, I could say, well, I don't want my spouse to be the one, or I don't want my child further down the list to be the one making my decisions. I could actually go, even though I'm incapable, to the board and ask the board to name Genevieve ahead of someone else on the list. Now, again, that's rare, but I've seen it over the years where two clients of a mental health facility have some sort of relationship or friendship, and one will then go to the board and say, well, I want, the person two doors down to make my decisions, not my family. So it can happen. The other option, of course, is that Genevieve, even if I'm quite incapable and not really looking at these issues, she might think, wow, Mary Jane didn't really want her spouse or her young adult child to be making these decisions, but she never got around to writing a power of attorney. Genevieve could apply to the Consent Capacity Board to be named a representative. So it happens. It sometimes happens when someone, because the caregiver or the substitute decision maker is incapable themselves and they lose their authority, sometimes they go to the board to try to outrank themselves and get the authority back, but relatively rare. Most times you're going to see that it becomes a family member, spouse or partner, child or parent. So again, adult children of an elderly person, parents of the patient, maybe a young patient, etc. There are some nuances around a parent who has full right of custody versus under number 6, someone who is the access parent. And I always say to practitioners, on this hierarchy, let's say dad outranks mom, but you also, if there are family law, divorce, custody type proceedings underway, a court may have ordered that the mom be elevated back to decision making and access to information. So you just have to watch out for that as well. And then it just goes on with other family members, brother or sister, any other relative. For practitioners, you do not have to go to the ends of the earth. You've already said you're committed to use personal health information of that patient to try to find the right substitute decision maker, but you're not going to do a forensic analysis and look up every George Smith and everything else. And sometimes you're going to be limited because the patient is not going to tell you anything, or one of the potential substitute decision makers is not going to divulge. So you should say, is the patient married, or any of these other things at play? Is there another sibling? Because the other thing to consider is equally ranked substitute decision makers, let's say 2 parents or 4 siblings who are the children of the patient, they have to make the decision together. We're going to come to that. Last thing to say as well, public guardian and trustee is the substitute decision maker of last resort. So we do have situations where a patient has nobody. You go down the list really quickly and you realize this is a person, we have this privilege to serve the person. They do not have a caregiver or a substitute decision maker standing in the wings. Public guardian and trustee treatment decisions unit gets called. There is someone for everyone, in other words.
Thanks, Mary Jane. That's a good review of that list. And interesting to note that we all have a substitute decision maker.
And if you don't like the one that you have, sign a power of attorney in favor of someone else. And the other thing to know about it as well is there is no equivalent hierarchy over on the property management side of the house. So again, if you don't have a power of attorney for property, which is the companion one under the Substitute Decisions Act, if something happens to you, your loved ones are going to have to go off and get it sorted. So that's just a quick comment.
So it's clear from the review of the substitute decision makers that it may or may not be the caregiver, whether it's family or friends. So why is it important for a caregiver to know who will be the patient's substitute decision maker?
And it's important as well for the practitioners to know, because sometimes there's an assumption that, this wonderful caregiver who's been accompanying the person to all of their appointments, picking up medications, doing everything to support the person, the assumption is that that individual someday when the patient becomes incapable will be the substitute decision maker. And as you see from the list, that may or may not be true. Or even if that caregiver, who again has been working tirelessly, it's possible that they are a substitute decision maker, but someone else is equally ranked with them. If they are married, parents of a child, etc., if they are, there are 5 siblings and the patient is that elderly person, that's precisely what we need to know. So it's extremely important that we know whether the caregiver becomes the substitute decision maker, and then it also flows into the request for the caregiver to get information, because imagining the frustration of the caregiver today while the patient is capable, and even where the caregiver is bringing a copy of a consent, or the consent doesn't have to be in writing, it could be the patient leaves a voicemail saying, please make sure that my mom gets access to my information. That's still a consent. Imagine the scenario where we're now dealing with an incapable patient who has a substitute decision maker who's not the caregiver. So the caregiver now, in terms of all of the consent, has to have the consent of the substitute decision maker. And again, sometimes that works just fine in a perfect world, but there are situations where there are family tensions, or a substitute decision maker gets to control the information and sometimes will shut down the flow of information. So I think really for the Change Foundation, we started from the premise that there were barriers even where a capable patient was authorizing, giving consent to the caregiver to get information. And how do we make sure that, if I'm consenting, that Genevieve gets what she needs? And then you get to the other extreme, that if and when there's a finding of incapacity, maybe the caregiver is the person who becomes a substitute decision maker, but not always. And again, this is where practitioners sometimes pause to think, do I have the right person? And I've had a number of cases over the years where we found out later, oh my gosh, we've been working only with one substitute decision maker. Now it turns out that they're, it's a family of 4 people equally ranked. And now we have to go back and I just say, look, we apologize. As a result of this review, we've determined that, there's more than one, and now we're going to come to all of you. So I do say healthcare providers shouldn't hesitate to share information if they have a consent. And consent, again, can be a written form, and it often is for release of records, but if it's just for the sharing of information, ideally it gets documented in a way that other practitioners also know. And it's frustrating for caregivers when they go to one appointment after another, and they're the family historian, they're giving all the information. The information actually emanates from them, and then later they're blocked, even when they were the ones providing it in the first place.
So just briefly talk about who can be a substitute decision maker, and then you alluded to when siblings or multiple substitute decision makers that are equally ranked don't agree, and we're going to talk about that a bit more in a minute, and how that could get sorted on a formal basis. So just briefly, who can be a substitute decision maker?
So there are rules, and it's important. There's not an official mechanism in Ontario as to how a caregiver would be told of the responsibilities of becoming a substitute decision maker. And there was a court case some years ago that just in passing said, look, practitioners, you really have a duty to let people know what their responsibilities are, because given that as a substitute decision maker, you're meant to act in the best interest. Well, that's a defined term in the healthcare consent act. How would that person know what the rules are? The prerequisites, though, to even become a substitute decision maker are substitute decision maker has to be willing. And so that just gently means that a person could be uninterested or unable to do it, not because of their own capacity, but just their circumstance. And that's fine. We don't judge. If a health practitioner turns to that highest ranked person, they may just need to go to the next. So if they're not willing, that's fine. They have to be willing. They have to be available. Available is a lot easier than it used to be because we're all connected electronically. So willing, available, and available can also mean, you know, if we have to call you 6 times as the practitioner to say we need a decision, well, if there's an urgent situation, we are probably going to move on. If it's an emergency, there are other rules that apply under the Healthcare Consent Act, but we might ultimately write a letter saying, you know, we've been trying continually to reach out to you. You're not coming to some of the meetings. You know, we've done it on these occasions, and we would like to get you, and otherwise we will move on and should move on. Sometimes by the time I'm involved, it's gone on for quite a while. So willing, available, at least 16, unless of course this is a 15-year-old mother of a baby. She would be entitled, but that again is the rare situation. The person who's a substitute decision maker can't be prohibited by court order or separation agreement, which makes sense. And an important one is that the substitute decision maker, in addition to being willing, available, etc., has to be capable, him or herself. So do they meet the test? Are they able to understand the information and to appreciate the reasonably foreseeable consequences? In that instance, if the practitioner finds, yeah, you know what, that family member, that substitute decision maker is incapable themselves, they can actually bypass. There's no appeal route. It's not like taking someone to the board for not, you know, for making poor decisions for the patient. They simply bypass, which is controversial. That's for another day.
So let's talk about the special situations where the substitute decision makers, there's more than one and they really don't agree. So what are the steps we go through to get to a treatment decision, for example?
Yeah, and you will have some of those tensions amongst those equally ranked substitute decision makers. Sometimes in the family situation, someone will say, I really, really want her to be treated. The other person will say, well, you know, she never really wanted this kind of treatment, etc. If people are equally ranked as substitute decision makers, again, parents of a child, adult children of an elderly person, let's say, if they're equally ranked, they must agree. If they cannot agree, remember I said that public guardian and trustee is a substitute decision maker of last resort. If you have no one, they have one other role, which is to step in to be the tiebreaker. And so we usually, as we get into these fraught situations where substitute decision makers are dueling over the decision and they can't come to consensus, the practitioners would normally just say, gently but firmly, we do need a decision and you're going to have to bring it to us, because otherwise, if you can't agree, we don't have any choice. We will need to have the public guardian and trustee make the decision. That's probably not what the person would want, etc. So staff also sometimes get pulled into the dynamics. Staff might come and say, well, why is it that that, you know, parent who never comes and visits or doesn't bring the person to appointments or hasn't been engaged over the past couple of years since the person's come into service with us, how come that person gets equal billing, if you will? And that can be, but that's not the legal test. I had a case one time where one of the substitute decision makers, and it happened to be an end-of-life decision, one of the equally ranked people was in jail, and staff came and said, well, the person's in jail, they can't be making a decision. I said, well, if they're unwilling or unavailable or they don't meet the other criteria, that's one thing, but we obviously are, you know, we have to turn to the legal substitute decision makers, and these rules still, but we got it sorted, but it took a little finessing to get to that. So just caution your staff to decide, let them know, bring us the decision, etc. And otherwise they will lose the power to make that decision. It doesn't go away forever. For the next one, we'll be asking them again. But for that decision, we would turn to the treatment decisions unit at the public guardian trustee.
Great, thank you. So now we're going to go back to that issue about age limits, and you guys submitted a question about that. So assuming that a child is capable, if they're incapable, the substitute decision maker would make treatment and information decisions. But what are age limits to consent for treatment or information sharing if a child or young adult is capable?
Right, and it's an important distinction. You would think, given that in the drafting we were using the best of the Healthcare Consent Act to create a similar framework for consent, capacity, substitute decision making, that they would be identical. Hierarchy is identical. There's a thing that we need to point to, being that in terms of age, you'll recall that I said before, there is no age to consent to treatment. So I could be quite young and capable, I could be quite old, I could have whatever diagnosis. There are special rules under PHIPAA that were drafted in that have to do with a child under the age of 16. So it's right there for you, but I'll just go through it really quickly. And this is not to do with treatment. So remember I said, if someone is a substitute decision maker for treatment, they already make all of the information. The nuance here is, an example I sometimes use is, I have a 15-year-old son who needs a camp note from the doctor. Otherwise, he's not going to be allowed to go to camp. You can imagine my 15-year-old son is not going to be so inclined, even if he has the right under PHIPAA, to be the one to organize it and give the consent to the disclosure of his personal health information. If under 16, child or parent can give the consent to collection, use, and disclosure of health information, assuming we're all capable. 16 and over, the child makes the decision, gives the consent, and can also, frankly, delegate the consent. You cannot delegate consent to treatment, but you can delegate. So my son, let's say when he turns 16 next year, he could just say to the doctor, talk to my mom. Fair enough. So under 16, either the child who's capable or the parent can give the consent to the flow of information. 16 or over, it's a child. So the only exception, though, to my right to make information decisions for someone under 16 is, let's say that my son went to a health practitioner and got treatment for something, capably consented to his own treatment. In that case, it would have to be him giving the consent to the collection, use, or disclosure, or he could consent to my doing it. Or if it's counseling under the former Child and Family Services Act, if he consented in his own right, then it would be up to him. So I think that's one to just come back to at some point and consider, because under the Healthcare Consent Act for treatment, no age, but there are these special rules under PHIPAA. So pause on those if you are dealing with youth clients of that age.
Okay, great. So are there any special rules around information sharing that apply specifically in mental health settings?
So one of the things that we did in drafting PHIPAA was to try to pull out of all of the other statutes in Ontario any of the rules around collection, use, and disclosure of personal health information. So a lot of stuff just came under the rubric of PHIPAA. But a few things stayed behind in the Mental Health Act. So just really quickly, a couple of things to recall. There are special rules, of course, express or implied consent of the capable patient. Sometimes there's no consent required. So either under PHIPAA or some other law. As I mentioned, Form 1, application for psychiatric assessment, it says right on it, you have the ability to collect collateral information. So we're either looking for authority under PHIPAA or under some other law. If it requires or permits it, then that's what we look to. One of the provisions that stayed behind in the Mental Health Act is Section 35 sub 2. So again, this is only where someone is detained involuntarily under the Mental Health Act, or is a patient of a mental health facility under the Mental Health Act, or is a forensic client under the Criminal Code mental disorder provision. So in those two instances, a patient cannot turn to the practitioner and say, I would like to lock my information down. I don't want it to flow amongst the practitioners. That wouldn't be permitted. So there, again, there is the ability to continue to share it, to give it to the parents, etc., in that nuanced way, even if that person in the mental health facility is saying no consent required. So again, it's a very specific circumstance, but just remember that it's there, and that patient has no appeal to the privacy commissioner either, because it's not under PHIPAA.
Interesting intersection of the legislation there. And so you mentioned the term lockbox, and that's come up sometimes in our discussions. So could you explain the term to us a little bit and talk about how it might be used?
One of the things about PHIPAA is we refer to a lockbox, but the word lockbox is not in there. So under a couple of sections, 37 and 38 of PHIPAA, there is this express instruction of a patient to not share. It's probably not grammatically great, but there's an express instruction that their personal health information not be shared with certain healthcare providers. And the interesting thing here is we will have mental health clients who say, look, I don't want any of my personal health information to ever see the light of day for any purpose. And we have to, again, gently remind them that a lockbox only ever applies to the flow of information amongst the treating practitioners, either within the organization or maybe disclosing it to another of practitioners in another organization. You know, let's say between the mental health unit of a hospital and the family physician, or between the community mental health and addictions agency back to another provider. So that is really what we call the lockbox. Said if that person's involuntarily detained under the Mental Health Act or they're a forensic client, already they've got that Section 35 sub 2 provision to deal with. And I've said here, patients get frustrated because they think they're going to lock everything down, but there are always many ways that their information will get used, many ways it will get disclosed through PHIPAA or some other statute. So that's just a quick primer on what a lockbox gives you or doesn't give you. And to be really clear, most healthcare organizations don't hand over a brochure or sit a person down when they come in to say, hey, would you like a lockbox? We've not done that. And it's not to say that it's not their right to have it, but most organizations wait until it comes up. And I don't think that's disingenuous. It's just that's the way the process has gone. And again, it may vary from one to another, but generally speaking, we respond to lockbox requests if and when they happen. And I think caregivers and family members feel better about that. They, you know, there's always that tension that everyone is cloaked in rights to, you know, not be treated, to not have anyone share their information, etc.
Sounds like it doesn't happen real often. So
yeah,
but
periodically.
Thanks for explaining it to us. And just one kind of brief, a final slide before we get into a bit of a scenario. Do caregivers have their own rights to access the patient's health record, which we've talked about a lot of those examples where they would or wouldn't. And what if some of that information in the health record is about the caregiver?
It's a really good question. We've had precisely that issue unfold numerous times over the years. Let's say that the parents of a young adult patient know that that patient has been telling the practitioner all kinds of stuff about family history. Family history is still considered to be personal health information of the patient. So caregiver does not have any inherent right to go and say, I would like access to it. There is no right of access. Now, a substitute decision maker is a different scenario. Substitute decision maker would step into the shoes of the incapable patient and exercise all of the rights of access. But if it's simply that I would like to know what my 15-year-old son said about me to the practitioner, or we've even had where, you know, a parent is sitting in a room in a meeting with the healthcare practitioners and sees that someone is writing something down and wants to know what it is, you know, and was that about me? That's not going to happen. So it's either the capable patient or the substitute decision maker that has the right of access.
Thanks, Mary Jane. And before we get into the next kind of scenario, I think we've answered most of the questions that were previously submitted, but we've gotten a few in. So I think it might be a good time to take some of those now, and then we'll see if we have time to go through this scenario. But one of the questions that was previously submitted would be covered in the scenario, and that's the question about can you sign a consent at home and then, you know, have that be brought later. So we'll talk about that in a minute, but let's go to the questions that you guys have typed in on the screen. And I think the first one was, at what age can you consent to an abortion without the parent's consent?
As far as I know, termination of a pregnancy is a legal service. similar to any other. I'm not aware that there would be a specific age. It would be under the same rules in terms of capacity to consent. Now, you know, it seems to me that anyone offering that service would, in supporting that particular client, would be strongly encouraging that person to involve family or friends or other support. But in terms of, I'm not aware that there would be any special rule that singles out abortion, termination of a pregnancy. Otherwise,
so it would be like any other procedure if they have the capability to understand the procedure and the
legal
risks.
capacity to understand the information. And again, this will be very controversial because I have a 13-year-old daughter. Putting yourself in the shoes of a parent, you know, you would absolutely want to know. I'm finally at the age where those kids are going to be making their own decisions of all kinds of decisions. But there's nothing that I'm aware of where termination of a pregnancy would attract any special, you know, subset of the rules around consent to treatment. Having said that, it's like the other information sharing where we said there, I would hope there would be a very nuanced conversation and support in everything else because of the significance of that decision.
But the type of procedure itself doesn't dictate a different set of regulations.
No.
Thanks. The next question was, if a patient is admitted on a Form 1 and is acutely psychotic and agitated, difficult to control, can a healthcare provider administer medication for the safety of the patient and the safety of others, even if they haven't obtained consent for administering that medication?
That is a great question, and the answer is yes. So that would not be treatment, technically under the Healthcare Consent Act. That would be chemical restraint. So chemical restraint by common law means that you could administer that drug, and it, to be quite frank, it could be the same drug that would be proposed as a treatment. The difference is, you know, we're always alive to the potential that I might turn as a practitioner to Genevieve and say, you know, I'm assessing your capacity and you appear to be capable, you meet the test, and I'm going to ask you, do you consent to this treatment? And then you say no. Well, saying no doesn't make you incapable. And saying no doesn't then mean that you immediately turn and say, well, I'm going to give it to you anyway, and I'm going to chemically restrain you as an IM injection every 6 hours for the next X days, because that's not chemical restraint. That is treatment. So you're allowed to chemically restrain with the proviso that, you know, you only do what you need to control the situation in the moment. When the risk is over, you don't keep chemically restraining under the guise of treatment. So that issue has come up a lot over time, but that is not treatment of the patient, that's chemical restraint.
Thanks. Thanks for that answer. Good question. So another question that was submitted is, if you have a client with no insight and the substitute decision maker is making decisions that are worrisome to the healthcare provider, for example, moving someone out of a retirement home to live with them, the client's money seems to be disappearing, what can the healthcare provider do in this kind of situation when the substitute decision maker doesn't seem to be doing their job in the best interest of the patient or client, and they're not returning calls and they can't get in touch with them? So what can a healthcare provider do for the safety of the patient in this situation?
Yeah, this is a really good layered question that you're posing, because first of all, if they don't meet the requirements to be an SDM, the substitute decision maker, remember they have to be willing, available, and capable. So the first thing I always do when we face that kind of situation is I talk to the healthcare practitioners about whether, in fact, we think that this arguably poor decision by the substitute decision maker is driven by, you know, their unwillingness or unavailability, and we can sometimes sort that. What if they're just making a really poor decision, and then we get to the point where we think, well, if the substitute decision maker is making an incapable decision, remember I said you could bypass them and go to the next person. You would probably document. I found Genevieve incapable, you know, on this basis according to the test, and we're moving on to the next highest ranked person. One of the things is the scenario that we just read out speaks to, though, is what if they are capably making a really poor decision, not in the best interest, which has special meaning of the Healthcare Consent Act. So if it's about treatment, then the attending practitioner, proposing practitioner, could go to the Consent Capacity Board, do a Form G application, and put it over to the Consent Capacity Board panel to say, is this substitute decision maker acting in the person's best interest? And then you would probably lay out, why it is that they are not. One of the challenges, and I'm seeing this often now, is sometimes we have unfortunate and really poor behavior of a substitute decision maker when there's not a treatment on the table. And so there really isn't a mechanism. Or, for example, if you get a patient who's making an arguably poor, lousy, capable decision, you can't go to the board to say you're not acting in your own best interest. So this is very frustrating for healthcare practitioners. If an SDM is being, abusive or aggressive or making, again, poor choices that are not to do with the treatment, you don't have that automatic avenue. And so we've been looking at a lot of what else can that healthcare practitioner or organization do in terms of the substitute decision maker? So that was an excellent question, because again,
really
it raised about 3 or 4 different angles.
Right, and there's one more question just below that. If there's a consent to share information with the caregivers, signed on file in the medical record or some other, paper copy, either, in a clinic or at the hospital.
Or documentation of a verbal consent.
Right. Do healthcare providers have to ask for consent again when the patient is again admitted? Or does the consent just stay on file? You said before that it doesn't expire. So is there a reason why healthcare providers have to ask again? Do they have consent to share health information with this person?
Well, I don't think there's a legal requirement necessarily that they have to ask again. But, if I've not been there as a patient for some time or a client of that particular organization, some things may have changed, either in the relationship or in the kind of information that's in my record. So while it's not necessarily legally required, it's not a bad refresh to just say, oh, I see here that, we would still share the information with your mom, and to check back on it. So I know from the caregiver's perspective, they're probably thinking, oh my gosh, don't do that, because then the person's going to reconsider and withdraw it. But there's nothing ever to stop the practitioner from, checking in with the person and making sure that that's still okay, because sometimes, frankly, patients consent to the release of their records for all kinds of reasons, including caregivers or other third parties, without really knowing the consequence. So I'm not as worried about it being shared with caregivers, frankly, for all the right reasons, but it can go out in many ways around the sector and have some impact that or they didn't even really know what was in there. Oh, I didn't know that you meant that, some third party is going to receive all of this and that's going to follow me. So again, that's with all due respect to caregivers, but even if it doesn't expire, I don't think that means that you would never raise it again.
Thanks, Mary Jane. So if there's no other questions coming in right at the moment, I think we've answered the ones that you guys have typed in, and just about all the ones that were pre-submitted, the last 2 of which that I have on my list that we haven't addressed yet. One will be addressed talking about this scenario for a person named Andrew, who's a young adult, worried perhaps that his healthcare provider will share his health information with his parents or collect information from them. And so I'm just going to have Mary Jane kind of walk us through the, things around that kind of situation.
And I think we've touched on some of this already. So we've said, look, Andrew is feeling a little uneasy about the sharing app. So what do you do as a healthcare practitioner? Again, we talked about reminding Andrew that, he may need the support of, let's say it's his parents who are the caregivers. If they're substitute decision makers, it's going to be a different situation. And, we used to think that the practitioners couldn't share stuff with the parents, but they could listen as much as they wanted to. We talked about why we've got that weird business around collection now and the timeliness and accuracy piece. So, and again, I said, what if the provider's worried about breaching privacy? Just to level the playing field and understand that you certainly can collect in certain circumstances, and have a conversation with Andrew about what's behind the worry, and what if you only share a certain amount. It doesn't mean it's going to be the whole record. We talked about age, so if he's 15, it really is Andrew's decision, or the parents, as to whether or not the information will be shared, as long as he's capable. If he's 25, same thing, presumed capable to consent to the collection, use, and disclosure of the information. So there really isn't a whole lot of difference on age in that instance. I would just refer you back to those special rules for kids. And we would want to know, what is the role of the parent? So is the parent a caregiver? And I'm not suggesting it's a lesser ranking, but if Andrew is capable, parent's the caregiver, we want to know, has Andrew given the consent to share it? And again, have the nuanced conversation. What if he's on a Form 1 under the Mental Health Act? We've talked about that. Form 1, right on the form, says that you can collect collateral information. So I would certainly recommend that you turn to parents and collect what you need to in the circumstances. If Andrew's detained on a Form 4, Form 3 or Form 4, involuntarily in a mental health facility, again, going back to that special Section 35 sub 2 of the Mental Health Act, there may be a reason that you do need to turn to Andrew's parents to collect something from them. And the practitioner may have to say to Andrew, we're not going to collect everything that there could be, but we do need an answer to this question. In fact, we're permitted to. So 35 sub 2 in that narrow circumstance gives authority to collect it without consent. We're not talking timeliness or accuracy, etc. If he says, I want to lock it, again, that's amongst healthcare practitioners, either within your organization or other practitioners involved in his care. And, again, he may not use that particular language, but there are limits on that. He may think it's never going to be shared with anyone, even if there's a risk situation. Remember, to reduce or eliminate a significant risk of serious bodily harm, you can and should be sharing information with any person, including calling the parents, calling the police, whoever needs to know to reduce that risk.
So just continuing on with Andrew for a moment, let's say, he lives at home for a while and even takes his treatment, and then some other things start to happen. And we're going to address the issue that was submitted in a question form prior to the webinar about, if somebody's competent and at home, can they sign a consent form that will say, this applies when I'm not competent anymore? So can you talk about that situation after we talk about some of the other nuances with Andrew's case here?
Yeah, so I've just created a scenario, which is not an unusual one. Let's say he's been in and out of mental health facilities, or not. Maybe he's, in the early stages of this journey, sadly. So perhaps with his own consent, or more likely substitute consent, Andrew starts getting treated. As I said, the whole cycle may be that he starts to feel better and he doesn't have insight to the fact that he's ill and needs to take treatment, stops taking it, declines, and this is what we see quite often. The behaviors return, the family, and we've said, here are a few things. Again, try to have any physician who's seen him within 7 days sign. It doesn't have to be a psychiatrist. Sign the Form 1, start the process over, document everything in case someone, either the health practitioner or part of the team or the family, ends up going to a justice of the peace. Police, sometimes you wait until there's police involvement. Police have their own authority under Section 17 to step in and act. And, another scenario we often see is that Andrew gets there, it's up to 72 hours in hospital to sort out whether he's going to stay or go. And then all of a sudden, the family's thinking, we have a little bit of respite now, and he comes home 20 hours in, unannounced, not ideal. So your question was, given the havoc that this plays, and we've seen individuals come out of this type of scenario having lost a year of their lives, untreated, you know, pursuing all of their appeals. They're allowed to do that. That's the way the system is set up. What if Andrew were to say to his parents, I don't want to see that happen again? Even if someday when I deteriorate, I start to say I don't want to be treated, what I'm telling you today, capably, is I want to be treated. So he could do this, but it involves what we unofficially call a Ulysses contract that's prepared under the Substitute Decisions Act. So it's at least an option where the caregiver, you know, could take Andrew to a lawyer, and Andrew could decide, look, I don't want that to happen again. I'm going to consent now for a future, pretty much foreseeable event, and don't listen. That's why it's nicknamed, it's not called Ulysses contract in the Substitute Decisions Act, but that's what it's been nicknamed, because, you know, he's saying now, ignore me someday when I tell you I don't want treatment. So it's, but again, that's a fairly intrusive mechanism for Andrew, but it's one that might bring some relief to potentially to him and to caregivers.
Thanks, Mary Jane. So we have the questions slide up there, but you've already submitted lots of questions, and it really added to the discussion about a paper. And the one thing that we hadn't addressed yet, Pierce telling me there's another question coming in. But before we answer that, I just want to address one that came in before the webinar, and that was, what tools can help, have we seen that can help educate providers? What's out there? So I'll just refer to the end of the report. There are several resources available. And then Mary Jane, when we were preparing for the webinar, mentioned the Canadian Mental Health Association Toolkit, which I don't think we have as a reference on there, but obviously for mental health scenarios would be helpple. Yeah, for this community. So again, we've pointed you to things like the Information Privacy Commissioner's site, and the Psychiatric Patient Advocate Office has general resources. I mean, they're certainly patient-oriented and patients' rights-oriented, but they do explain the law. The Ombudsman is a new place that people can go in the province. There are different materials on the Consent and Capacity Board website. So there are all of these resources that we've laid out. And as Genevieve said, there's also the CMHA Ontario Privacy Toolkit. It used to be at privacytoolkit.ca, and I helped them back in 2005 when PHIPAA had just come out in 2004 to try to just get a bit of a plain language and what kinds of questions might we expect and that kind of thing. So it's been updated just this year and is available. And again, it was a primer mainly for health practitioners working in mental health, but it does lay out some of the rules. And again, I was trying to think of the mental health lens and what can we almost anticipate that Andrew and other patients might be raising. How do we equip the health practitioners to have that nuanced conversations? And again, how do we assist caregivers who are working tirelessly to support this individual to have the same information and to be well equipped to navigate the system so that everyone has the same rules at hand? So that really was the impetus, I think, of this particular work of the Change Foundation. I was thrilled when they raised the fact that, you know, these are issues that are coming up often and are of real concern to caregivers. And I would add that this report that has been, will be released soon, is also another resource. Now, Pierre's walking over to, we're about to get the hook, but you guys have put in a couple other questions. So I'm assuming that you want to continue this discussion. So thank you for that. Oh, there's a good one. Let me speak maybe to the, so how is the Ulysses contract different than an advanced care directive? It's a good question. My understanding is it's a bit more intrusive because it really is that individual. The best way to explain it is with the Ulysses contract, I would be making that decision today. I would actually in many ways be giving a consent to my future treatment. In Ontario, a power of attorney for personal care, I mean, it's referred to here as an advanced directive. It's a wish.
So when I sit down and write a power of attorney for personal care, or I say to Genevieve, someday, if I'm in that situation, I wouldn't want to have that. I don't want that treatment. I wouldn't like the side effects. That would be the practitioner then turning to Genevieve to say, I'm proposing a treatment for Mary Jane. Here are the risks and the benefits, the alternatives, etc. It would be up to Genevieve to interpret my wish. Healthcare, in fact, that's why we don't call them advanced directives, because the healthcare practitioner is not allowed to just pick up the piece of paper and say, oh, that's what she said, let's go ahead and treat or not treat. You always have to turn to the substitute decision maker to interpret the wish of the patient. Is there a prior capable wish? And if there isn't, what were my values and beliefs that apply? So the key difference to my mind is, if you take me to a lawyer and we draw up this quite intrusive contract under the Substitute Decisions Act, I'm basically agreeing today, while capable, in terms of something that will happen down the road. There is a provision in the Healthcare Consent Act, consent to a plan of treatment, that could be done in that way, but in this particular case, to my mind, it's quite different. One is a consent to what happens in future. The other is my wish for you to interpret someday if and when we're in that situation. So you still have to get the consent, and you could interpret it differently, or you could go off to the board and say, well, she said she didn't want to be treated with antipsychotics, but there's a newer class with fewer side effects, and ask the board whether they would give you permission to depart from my staunch wish never to be treated if that were the case. So,
and we do have one more question as well. If a patient is in the hospital on a Form 3 or 4 and refusing to share information with the family is obviously quite concerned about the patient and demanding information from the healthcare providers. What's the duty of the healthcare provider to the family in that special circumstances where they're in on a Form 3 or 4?
Right. So sometimes the way we see that play out is a family member, a caregiver, again, who's not the substitute decision maker, will call the mental health unit of the hospital or one of the standalone facilities, or call around to many of them and say, do you have my person? And for the longest time, many of the hospitals took the view that they would almost say, I can neither confirm nor deny, or they would more gently say, I can't comment on whether or not she's here, but if she's here, I can pass on the message and see if she would like to connect with you. And again, you can imagine how frustrating that is. And even if, let's say, you're the parent of a child in that facility, if that person, and again, I don't know if you use the Form 3 or 4 just in terms of the involuntary status, or somehow that's supposed to factor into, how could they possibly be capable to make an information decision? But the practitioner is going to have to sort out, are they capable to make that decision about the flow of information and sharing? Because the default would be the practitioner has to figure out, well, what legal authority do they have? If they've had that nuanced conversation, ideally, if ultimately that patient says, no, I don't want to share, I know how frustrating this is, but the practitioner is then a bit hemmed in, unless they're reaching out for some other reason, and we're not talking Form 1 collateral, because we're not trying to find a substitute decision maker, maybe we're not at that stage yet either. And other than the discretion to warn, I don't know what that looks like exactly, to reduce or eliminate a significant risk of serious bodily harm, HIPAA and other laws don't really give much opportunity, other than, as I said, the healthcare practitioner can invite and cajole and suggest and persuade and do all of those things. I'm not saying coerce, but just have the conversation. But otherwise, their hands are a bit tied as well. So I know that is a source of contention, in that people get the right, if they're capable, to shut it down, just as any of us would. But I think what I'm reading into it is that, this is a bit different because they're on a Form 3 or 4. Now, the only other thing I could say is, if they're on a Form 3 or 4, remember the Section 35 sub 2 of the Mental Health Act. They would be detained under the Mental Health Act, and maybe you could convince the practitioner to exercise that authority because you've got important information that you can provide. I guess that's the only other way.
That one sounds like a difficult one to answer.
Well, it's just not satisfying.
Yeah, without being kind of in the case.
Well, but even for caregivers, it's just frustrating. Because ultimately, even if we've done all of those good things that we should have the conversation, if the capable person says no, I guess it's no, unless we can find some other way to give the healthcare practitioner, I mean, the duty, although every organization will say it's client and family centered, there may be times where the client has rights that are going to impact the family, and the healthcare practitioner doesn't, have the opportunity to override unless they find something else in the law that would permit it. It's tough.
Thanks, Mary Jane, and thanks for participating. I know it was, an hour and a half, and you all
a lot.
Obviously were paying attention and asking great questions and took the time. We really appreciate that you took the time to get together and submit questions ahead of time. It really helped craft the discussion, and I think we're all certainly much better informed and can ask better questions when situations come up where we're faced with privacy issues and consent issues and capacity issues. So I think it's been very informative, and I hope you've enjoyed it on your end. And thank you all for participating with us today. And thank you to Catherine and Pierre for keeping us online and on time today. So unless there's any further questions, I think we'll sign off from Toronto and hope everyone has a great day in Cornwall. Thank you.
Bye, everyone. Thank you.